Good morning, everyone. My name is Dulcie Foster, and I am the co-chair of Fredrikson Byron's White Collar and Regulatory Defense Group. We work with clients on a wide variety of government and internal investigations, ranging from fraud and other serious crime to sexual assault and immigration. Among the priorities that we have in our practice is managing investigations arising under the Foreign Corrupt Practices Act and other laws affecting business outside the United States. Welcome you here today. Before we get started, I'd like to introduce you to our panelists on our first panel, consisting of lawyers from Fredrikson and Byron. First, just to my left, we have Lousene Hoppe. Lousene is a litigator and white-collar defense attorney who represents clients accused of healthcare fraud, financial, and other crimes in our state and federal courts. She also focuses on Foreign Corrupt Practices Act investigations and due diligence, False Claims Act litigation, investigations of alleged regulatory or licensing violations, and related commercial litigation. In practice, she grapples with complex issues involving privilege and confidentiality, including related international laws, and in her role as Fredrikson and Byron's ethics counsel. Lousene will provide an overview of legal privileges outside the United States and the impact of managing internal investigations of those privileges. Next is Bob Oberlies, who is chair of our Asia practice and cross-border M&A groups. Bob's practice is focused on supporting U.S. companies in their international operations, particularly in Asia, where he worked for more than a decade, based in Hong Kong, Beijing, and Shanghai. Bob manages Fredrikson's Shanghai office, which we've had since 2006, and where we have a team of U.S. qualified Chinese attorneys supporting our clients' investments in Asia. Bob has extensive experience counseling clients on anti-corruption and related compliance issues and conducting internal investigations around those issues. Bob will discuss the increasingly thorny issues for investigators in China arising under that country's privacy, state secrets, and cybersecurity laws. Finally, last but not least, we have Sten-Erik Hoidal. Sten is the chair of our Data Protection and Cybersecurity Group and co-chair of our Business Litigation Group. Sten helps clients navigate the myriad of legal obligations relating to the data they process, including compliance with national and international data privacy laws. He also helps clients develop and implement security and privacy policies and procedures and evaluate risks associated with corporate practices and mergers and acquisitions. Sten is a certified information privacy professional accredited by the International Association of Privacy Professionals, and he will provide us with an overview of the complex issues involved in transferring data for purposes of cross-border investigations under the GDPR and other data privacy laws. Before we begin, I'd like to point out that there are cards on the tables for each of you to write questions throughout the session. We will have a Q&A at the end of both panels, but if you have a question in the meantime, you can either write it on the card or, given that we have a small group here, I think it would be great if you want to raise your hand. The panelists would be happy to take questions that way as well. So either way, whatever you're most comfortable with. And with that, let's begin with Lousene.
All right, good morning all. I'm happy to be kicking off things today talking about privilege, everybody's favorite topic, I'm sure. But you know, for those of us who engage in internal investigations, especially cross-border investigations, and who have to deal with this kind of work in our daily lives, privilege considerations in those situations is actually really important. And what I'm going to tell you is that privilege is different throughout the world. I'm sorry to say, bad news right up front. But we're going to talk through some of those issues and then some of the practical considerations that we can all keep in the back of our heads when we're starting investigations that can help us retain privilege and try to do our best despite a panoply of different kind of laws around the world. So my intro title here talks about legal professional privilege. That's kind of a term of art that really what I'm talking about there is things like attorney-client privilege, which we're all familiar with, work product doctrine, and I'm going to include in that the concept of client confidentiality, because that's a very important consideration, especially in civil law countries around the world. And we see that reflected in our ethics rules, in Rule 1.6 that admonishes us all to keep client information confidential. anything relating to remediation. So those are the types of concepts that are included in this broad umbrella. So first of all, some general observations. The good news is that most countries provide some protection for client confidential materials around the world. So most of the world where you're working in this day and age do have some similar doctrines, or at least doctrines related to protecting client secrets. And we'll go through sort of at a high level some of those today. But it's, there's a lot of different countries, very complex. I think we have an article here in the room today that you're welcome to take. I wrote an article in a publication for the MSBA regarding this, and it gets into a little bit more detail about individual specific countries. If you want to take that, is that in the back?
It's on the reg table, registration table.
So you can take it if you're interested on your way out. The scope of such protection really can vary a lot, though, and I'm going to focus a little bit on those differences here today. But I will say, even some of the more, shall we say, authoritarian regimes around the world, places you might not expect to have this, have been in recent years developing privilege or client confidentiality laws and statutes that, at least on the books, kind of afford some of the types of protections that we expect in America and in especially common law countries. So those are kind of three high-level things to keep in mind as we go along. So I'm going to talk a little bit first about some common differences in the United States, and I've split up this slide into common law versus civil law countries. This is general and high level. Different countries within these groups may have different rules on these things. So, common law countries, I'm talking about, Australia, England, Wales, Canada, Hong Kong, etc., those countries. So, in general, common law countries will have a pretty similar regime to what we have. For instance, Britain has something called legal advice privilege, which is similar to our attorney-client privilege. And they have something called litigation privilege, which is similar to what we think of as our work product doctrine. But within those categories, there can be some differences. And different common law countries actually have differences in their case law in this area and what's applicable. So some things to just be aware of. Even in fellow common law countries, there could be a different definition of the client in the terms of what is protected under a legal advice privilege, who is the client, and who's covered may be narrower than here. There often is in some common law countries, there's going to be a very narrow control group within the company that's considered a, quote, client. So a corollary of that concept is number 2 on the left hand there. It's that internal investigation interview notes with employees in some common law countries may not be privileged like we tend to expect here. They just don't consider just, sort of non-management and control employees to be people privileged in certain other common law countries. That's true in Britain. Canada has rules more similar to ours. So it really varies depending on what actual jurisdiction you may be conducting the interviews in. Another difference in common law countries, we sort of have this concept of a distinction between ordinary work product and opinion work product. We provide a really high level of protection for opinion work product that incorporates attorneys' observations and opinions in a memo or in some other kind of work product. And we distinguish that sometimes with ordinary work product, which we have some protection for, but it's a slightly lower level of protection in courts. And that may just be a gathering of facts or how we're putting together documents or things like that that may have some protection but lower. That distinction often doesn't exist in other countries. That's more of a United States kind of distinction. And so you have to be aware that there may be one standard for protection in other countries, and it may not be as high as our highest standard for protection of opinion work product. Finally, sharing privileged documents with third parties. That, depending on the country, may or may not waive privilege. There are, in certain other common law countries, if you're sharing privileged documents with a team, privilege is going to apply. And then in certain cases, even if that gets outside of a common privilege team, there are arguments and case law, this is positive in other countries compared to the US, that under certain cases, you may actually be able to claim privilege on those and not waive privilege. They don't have as strong of a doctrine on waiver of privilege in certain other common law countries. So that's just something to be aware of, that there may be a difference there. And the takeaway from all of that is, even if you're operating in a sort of a similarly common law country with those general principles of legal privilege, both for work product and attorney-client communications, there's still a lot of differences, and they could be really significant, and they could make a difference in when documents are requested or when attorney communications are requested either by subpoena or remediation. Now, in civil law countries, there's a very different sort of setup there. So in civil law countries, we're talking about statutes that are protecting client confidences. They can even be criminal law statutes that apply to attorneys directly. So in some of these countries, there are both civil and criminal laws that if you, as an attorney, reveal client confidences, you can have civil fines or potentially even criminal charges against you. But those are applied generally to the attorney directly. There's in many civil law countries, there's no sort of overarching law of privilege or concept of privilege like we have here. It's really all statute-based, and it's almost always directed at the individual attorney. So, for instance, privileged communications in civil law countries may exclude communications from lawyers who are bound to the client by a relationship of employment. In civil law countries, they don't consider in-house counsel. Sorry, our overhead has gone out somehow.
There we go.
Okay, it's back. In civil law countries, they don't consider in-house counsel to be privileged persons often the same way we do. And it may depend in that country on whether in-house attorneys are allowed to be admitted to sort of the bar in that country or not, and that depends on a whole other set of rules varied by the country. So this is important thing to consider in internal investigation. And I'll talk about it in a second, but just because you can't assume, especially in France, EU countries, South America, that if you're dealing with an in-house counsel at an organization based down there, that their communications with employees are going to be privileged unless you're present and outside counsel is present. So that's one thing. Professional secrecy laws, as I said, are imposed on the attorney, and even so in civil law countries, because they're imposed on the attorney, actually it brings in a broader depth of what materials are covered. So really, the client confidences that an attorney has in many civil law countries covers anything. It would cover anything that the lawyer has in their file related to the client nearly. So it could even cover things like communications with opposing counsel that the lawyer themselves is restricted from providing. So it's somewhat of a different concept, but it can be, cover more things in certain ways. But under this scenario in civil law countries, clients are not the ones that are necessarily in control of the privilege like we think of here, that it's really the client's privilege. It's really a duty on the lawyer rather than the client's privilege. So finally, before we move on, there we go. So a couple of things to keep in mind, that some of which I touched on. Understanding the law of the applicable jurisdiction at the outset of an investigation is really important with privilege when you're talking about international investigations. Just getting a grip on where you are, what kind of countries you are in, and whether there are differences in privilege laws are important so that you can take needed steps before that to do that. Educating your investigation team on those issues and making sure everybody's aware of that. Using outside counsel strategically, like I mentioned. In some countries, in-house counsel may not have privilege protections attached to them, and so it's really important in those countries to ensure, if you want to protect your investigations, about using outside counsel and having them involved in communications. And then, as I mentioned, in-house counsel, have them admitted to local regional bars where permitted, because then they might fall under the confidentiality rules and protections afforded in those countries, mostly civil law. Think about how you're storing confidential legal information and where you're storing it. And also sticking to oral communications in those jurisdictions with limited protection is always a good idea. That's not always possible, of course, but to the extent it is, that's something to consider. And then finally, be careful about dissemination of communication and documents to third parties because of how it differs from region to region on how third-party communications are protected.
Thanks, Lousene. And
Yeah.
next up, Bob's going to talk about cross-border investigations involving China.
Okay, good morning, everyone. So my focus is, of course, on China. China, we all know, is a big country. It's always been a complicated operating environment. Here's a slide that just shows the progress China has made over the last 50 years in terms of their economy. By some estimates, China is going to be the world's largest economy by 2030. Other estimates show, this one included, shows that they've already surpassed the U.S. This is data from 2018, that their share of the global economy is larger than the U.S., and then by 2040, this is what is we're expected to see. So what this means for us is just that for U.S. companies, China is, if it's not today, it will be soon the biggest market for your product. So many of our clients feel like they, despite all of the complexities with the trade war and the difficulties bilaterally, they can't afford not to be there, and they'll continue to sort of double down their investment because it's such a big market. But that presents challenges because despite the market getting bigger and bigger, it's still a very complicated operating environment. And what does that mean? It means that from a compliance perspective, it's the corruption. Corruption has always been an issue with public and private sector business. It continues to be. President Xi has had an anti-corruption campaign that's gone on for more than 7 years now. One of the longest in history, but regardless, an incredibly difficult problem to work out. And so it's, in terms of FCPA and anti-corruption in China, it continues to be one of the biggest issues that our clients face from a compliance perspective, and I don't see that changing at all. So investigations involving China is particularly for global companies, it's usually one of the top markets that you're going to have issues with. And one of the challenges is because of the difficulty between the relationship between the U.S. and China over the last few years and where it's going, it's making conducting these investigations even harder. We're seeing laws come out of the U.S., this certain tit for tat going on in terms of regulating what U.S. companies have to do, and then China saying what U.S. companies can and cannot do, what Chinese citizens and companies can and cannot do. And these are all making kind of the waters quite choppy in terms of how to conduct an investigation. So we're going to touch on just a few of those today. So I'm going to focus on two things. One is what I would call China's data sovereignty laws, and that is the cybersecurity law and the state secrets law. And then I'm going to talk a little bit about the conflict between certain U.S. laws and Chinese laws and how that influences how you conduct an investigation, and then what kind of remediation you have afterwards. The cybersecurity law was enacted in 2016. It came into force June 1st, 2017, and subsequently there's been a lot of other laws, guidelines, regulations, many of them non-binding currently just for comment, that have tried to clarify the parameters of the cybersecurity law. In some cases, they've made foreign companies very concerned about where things are moving, and in other cases, they've made things a little bit more confusing rather than clarifying, which is often the case with a lot of these implementing regulations. I'm going to talk about a few of the aspects of the cybersecurity law that have caused foreign companies the greatest amount of heartburn. One of them is this, when you look at the cybersecurity law, it was really China's first attempt at a comprehensive framework to set out the parameters of China's cyber sovereignty, cybersecurity, data privacy. This was the first time that they've really tackled it in any big comprehensive way. It's the first top-level law that has a data localization requirement, and ultimately it caused very significant changes in the way that companies had to operate, and they're having significant changes in terms of how we manage data, what data can come out, what you do with personal information, and it's really not since the data secrets, China secrecy law came out in 2010 that we've seen such a massive change in terms of how you handle data in China. One of the issues with the CSL is that there is now a requirement that you get that you explicitly inform employees how certain personal information is going to be used. This is not all that different from GDPR that Sten will talk about in a minute, but the implementing regulations have gone further and have required looks like the law is moving towards an explicit consent standard, where if you're going to be, depending on what you're doing with the data, where it's going to be exported, you're going to need explicit consent from employees before you're able to do that, assuming that the other parts of the law allow you to export the data. So what it really means for us is that the first place, there's a lot of best practices on dealing with this. What we really start with is looking at the policies of the company, figure out whether you've built in certain informed consent, explicit informed consent in the handbook and other policies. So at least we have some document that employees have reviewed, that they've signed off on, that has given this type of consent. Another area that has caused a lot of concern is the requirements on the restrictions on cross-border transfers of information. So when the CSL came out, they distinguished between network operators and critical information infrastructure operators. And the latter should be thought of, at least initially when the law came out, it's like the internet service providers, it's web hosting companies. It's companies that are in the business of handling massive data for third parties. But since 2016, this definition has expanded, and now there's some that think that ultimately it's broad enough with some of these implementing regulations to cover network operators. So as a best practice, what we see and what we often advise clients is that certainly it's a little bit unclear where the law is today in terms of what you, as let's say if it's a John Deere, you're not in the business of handling other people's data, it's just your own company's data. Can we export this data? Could we export this data as part of our investigation? And the law, it's clear that the law does not explicitly provide that a John Deere cannot export that data today, but it certainly looks like that's where the policy is going. And so as a best practice, many companies have started to kind of organize themselves so that you're not, as part of an investigation, you're not going to be exporting this data. And certainly if you are, that you're on notice that things are going to be changing potentially very quickly on this. There's also the localization requirement currently is only it's only covering critical information infrastructure operators. And so essentially the idea is that if there's going to be an export of data, you're going to segregate that data, you're going to get approval from the government before that gets exported, and generally you're probably not going to get the approval. So what it means in practice is that you're going to have kind of a decoupling of the way that data is handled, and your China data is going to stay in China, and you're going to need a team in China to review that data. And so outside of the investigations context, this has significant ramifications for lots of U.S. and foreign companies, because a lot of the business is handled, a lot of the services are handled by people in the U.S. and elsewhere. And so part of the services that are provided, they don't have the expertise in China to carry out certain service. And soon you're going to have to either abandon that business model or you're going to have to develop the local expertise to carry it out. I'll just say a couple words about China's secrecy laws. These have been around since 2010, and so we have more experience with how to deal with this. And generally, one of the challenges with the secrecy law is that they define what is a China secret very broadly, and it can, depending on your reading, and this is typical of Chinese legislation, they draft it broad enough so that it gives authorities maximum wiggle room to interpret it however they see fit. And so typically, though, what this really means in practice is that state-owned enterprises that U.S. companies or foreign companies might be interacting with could have state secrets. Typically, to be a state secret, it should be classified as a state secret. But if you're a company that does any work with state-owned enterprises, it's possible that in the course of doing business with them, they are giving you state secrets, and they might not be disclosing this to you. They just might be in your network through the work that you're doing to service their business. And that would be highly problematic if, as part of an investigation, that data was transferred out of China. And so for a long time, we've had protocols for how to screen for state secrets, and that those are still in place. If anything, the requirements for the CSL are being expanded, and we'll follow a similar format to what we do for the state secrets review. But in terms of some best practices on how to deal with this, a lot of this starts long before the investigation begins, and this is when you're dealing with state-owned enterprises, you should be making sure that your contract will have a rep and warranty that they are not going to be providing state secrets, and if they are providing state secrets, that it's clearly marked, and that you're going to be and that they'll also warranty that they are getting all necessary approvals for giving us the state secrets, and that those state secrets could be exported if needed as part of the investigation. Typically, if you put that language in your contract and they're reading it carefully, that's going to cause them some heartburn, and they may not give that to you, but it at least starts a conversation in terms of what is this relationship, and is there ever going to be a case where you're going to be transferring anything close to state secrets, and how are we going to deal with it? The next item I'll touch on is just with respect to kind of the conflict between U.S. laws and Chinese laws, and what that means for kind of the day-to-day practices for conducting an investigation in China. And one is with respect to witness interviews. Really important. Lousene touched on kind of all the differences with how privilege is handled. The second point here is just that there is no attorney-client privilege in China. And so this is a really important one to keep in mind. A Chinese law firm with Chinese lawyers, they are under a duty of confidentiality. But if the state comes to them and says, what did your client tell you? Did they do something wrong? They have a duty of candor to the state to tell them what the client did. So this is a huge problem, of course, from a U.S. legal practice. And so, what we typically would say is that for anything that you want privilege, you should be using a U.S. qualified lawyer. You should be using a law firm with a U.S. firm with a China office with U.S. qualified lawyers who are handling that to the extent that you want it privileged. And this is important too in the context of conducting witness interviews, and the Upjohn warnings are very important to provide, even more important to provide, so that it's very clear to the Chinese employees when you're the attorney or the in-house lawyer that's conducting this interview, and you're sitting down with them, it's very unclear to them exactly who you are, who are you representing, are you representing them? So the Upjohn warnings are very, very helpful, not only to preserve privilege, but also just kind of set the stage with the Chinese employees. So that you're representing the company, you're the company's counsel, the company reserves the right to reserve privilege. and it can waive that. And these are all items that are somewhat foreign concepts for your typical Chinese employee. Last item I'll just say is a couple points about remediation. And so, when you get to the end of your investigation and U.S. law, your U.S. Counsel is telling you that we should take certain action, which is dictated by FCPA jurisprudence, let's say, and that might mean that it is important for the company at this point to self-report. That's sort of the guidance that you're getting from a U.S. law perspective. China now has, and this is part of sort of the tit for tat that's going on between China and the U.S., they've come out with a law that prohibits Chinese companies and individuals from basically providing certain evidence to foreign criminal government authorities that are, as part of the foreign prosecution, you have to get Chinese government approval before you provide that information. So this is a strange situation potentially where you're the company ready to implement your remediation. You're starting to move towards to self-report, and potentially you'd have employees that would assert that we can't cooperate in this because we need to first get Chinese government approval. The other piece is just in terms of disciplinary action, and this fact scenario happens a lot more. And so often at the end of the investigation, you've found certain wrongdoing, and the recommendations from U.S. counsel is to terminate certain of these employees that have committed these violations. And so the recommendation is, let's say it's the general manager of your Shanghai plant, and because of all of the things that they were doing, whether kickbacks or bribery, the recommendation is terminate them immediately or as soon as possible. And this is really important from a U.S. perspective. Well, that has to be filtered through Chinese labor law. If that manager is a Chinese citizen, he's got a Chinese employment contract, he's protected by the Chinese labor law. For any of us who have worked with the Chinese labor law, we know that it's incredibly employee friendly. Labor tribunals side for the employees more than 90% of the time. And there are certain statutory grounds that you can terminate somebody. And if it's not one of the statutory grounds, you don't have any right to unilaterally terminate. So it's very different from the U.S. context where it's typically at will. Most people don't have an employment agreement in the U.S. And when you find evidence of this type of violation, it's usually very easy to terminate. In China, it's quite different. You might find significant evidence, enough to conclude that they should be terminated from a U.S. perspective, but you don't have enough from a Chinese labor law perspective. And so then it's a balance of, well, what should we do here? We can't, it's untenable to keep this person on, so we do need to terminate him, but usually it means that there has to be some sort of mutual termination, a settlement agreement. You need to pay him to leave, him or her, and or if that doesn't work and you unilaterally terminate, you have to be comfortable with the fact that you're going to face a wrongful termination claim and understand what the liability will come from there. So I think I'll stop there, and I'll turn it over to Sten. Other direction. Oh, there we go.
All right. Well, thank you, Bob. If we think of data privacy as a globe, I think the European view and approach to privacy is about as far away on that globe from China as it is on an actual globe. A very different view and approach to data privacy in the EU. Last summer of 2018, the EU had a really massive privacy law come into force, the General Data Protection Regulation. It really was the embodiment of the EU or the European view that privacy is a fundamental human right. It was a sweeping piece of legislation, very comprehensive, that had significant consequences for the companies to whom it applied, including in the context of cross-border investigations, and it creates several issues for cross-border investigations. I'm going to talk about 3 of those today. And by the way, I'm assuming some familiarity with GDPR. If you have questions about it after the presentation, feel free to stop and ask me. issue number one is what they call lawful basis for the processing. And processing is European data protection terminology. And it basically means anything you can do with the data. Deletion, analysis, transportation, modification, all of that is processing. So if you have an investigation in Europe, or an investigation that relates to personal data on people in the EU, the first question is, do you have a lawful basis to conduct that investigation, to do what you want to do with the data? And under the law, there are 6 lawful bases. I'm going to talk about 3 that are the most germane. And the first is consent. And you look at that and you say, well, that's pretty easy. I'll just go get consent from the individuals whose data I need to use as part of this investigation. But consent under the GDPR is like a gold standard. It is mythically hard to obtain. It has to be fully informed, specific. I mean, it is not an easy thing to do. And so the result of that is that it is infrequently relied upon as a lawful basis for processing. Sometimes, but you really have to go through some hoops to make it happen. And you have to be very careful when you're obtaining it. The next one then is the legal obligation. And the GDPR says that you have a lawful basis if the processing is necessary to comply with a legal obligation. The process would be, well, that looks pretty good too. I'll use that. Legal obligations only are those arising under EU or member state law. U.S. legal obligations are not a sufficient basis for the processing of the personal data. So if the investigation relates to the FCPA or something like that, this isn't going to afford you any protection, which means you have to default to the legitimate interest. And that is probably the most commonly used lawful basis for processing personal data. Lawful basis, legitimate interest is appropriate where the processing, what it means is that the processing is necessary for the company's legitimate interest, right? And there's some guidance on what legitimate interest means, but it requires basically a balancing test. So you've got to look at what impact it's going to have on the rights of the people in the EU whose data is going to be processed. Is it going to disproportionately impact them? And you also have to make sure that you are taking adequate steps to safeguard their personal data. So if you don't need the data, if you don't need some aspects of the personal data as part of the investigation, you shouldn't be taking it. Or if you can anonymize it or scrub it, you should be doing that. So step 1, you have to have a lawful basis to even do the investigation. Step 2, well, I've got a lawful basis, but I want to share it with some vendors as part of this investigation. Can I do it? And the sharing is prohibited with vendors. They call them processors under the GDPR and other data protection, EU data protection terminology. And it is prohibited unless you have certain requirements met in the contracts with the vendors. And there is a laundry list of these. I won't take you through them all. But it is, you have to give some forethought to it to make sure that you get the right stuff in the contract. Otherwise, when you share it with the vendor, you can wind up in some hot water. You could be in violation of the GDPR. So you got to work with counsel to make sure that you're getting the right stuff in the contract and understand that you're ultimately going to be liable for your processor's failure to adhere to whatever you put in the contract, failure to adhere to GDPR. The third issue, and this is probably the biggest one, is, all right, I've got a lawful basis, I got the right contracts in place, how do I get it out of the EU? I need to do the processing somewhere that's not in the EU. How can I get it out? And if you are a company that has same legal entity operations in both the EU and the United States, that's not a prohibited transfer. You can transfer within the same legal entity from the EU to the United States. Any subsequent transfers, problematic. If you are transferring it, it's a related company, but technically a different legal entity, so same group of companies, but different legal entity, that's a prohibited transfer, a restricted transfer. And you can't do it unless you're transferring it to the right country, or you have adequate safeguards or certain mechanisms in place. With regard to the right country, what the GDPR says is that there has to be adequate data protection legislation in the country you're transferring it to. And they actually have to get a formal adequacy decision from the European Commission. The United States has not gotten one of those. There are some countries that have: Argentina, Uruguay, Japan for certain types of data, Canada for certain types of data, but the U.S. is not one of them. So if you're transferring it here to the U.S., you're going to have an appropriate mechanism in place or the right types of safeguards in place. And there are several safeguards that you can use. One of those is the EU-US Privacy Shield, which is a self-certification program where you declare to, and it's only available for companies that are regulated by the FTC, so no banks, no insurance companies, but where you declare to the US government and to people at large that you adhere to this series of principles. And for those companies that are EU-US Privacy Shield certified, they can receive data from Europe. They have basically an exception. Another mechanism are these things called binding corporate rules, and this is useful in the situation of joint ventures, or we have a family of companies that are different legal entities. You can sign on to these binding corporate rules that you then take to the European regulators and get approved in Europe, and then those can allow transfers. Very few companies do that. It's kind of a laborious process, and it's literally like a handful of companies that have done that. So you're probably not going to do that. The most commonly relied upon mechanism is called standard contractual clauses, and the European Commission has issued these contractual requirements that the transferring entity and the transferee entity can sign on to, and it's basically a contract that exists for that one transaction where you're shipping that one data set over, and you have to adhere to those. That's what most people use, and that's probably the most common mechanism of getting data out of the EU. But say you get it out of the EU and now you need to turn it over to a regulator or administrative agency. Can you do that? And for a long time, that was an open question, and there was a lot of debate about that. The European Commission has fortunately provided the EU regulators have provided some guidance on this issue. And there is an exception. They call them derogations under the GDPR, so word of the day, derogations. There's an exception that applies for the situation where there is an investigation going on. Specifically, where the transfer is necessary for the establishment, exercise, or defense of legal claims. And the guidance makes it clear that that's contemplating, third country, outside of the EU investigations, whether it's antitrust, criminal, or whatever. And so that can provide you a basis for sharing it with a regulator. However, when you do so, you have to make sure that the sharing is adequate, relevant, and limited to what is necessary. So you can't share more data than is absolutely necessary. You have to be, the takeaway is you have to be thinking about what you actually need in that data set and scrubbing it down to the bare minimum. Otherwise, you risk being in violation of GDPR. And that, in a nutshell, is European data transfers.
Okay, thanks everyone. That's our first panel.